Hello, true believers. This is Babbles Only, and it's been a while since I've done one of these court type of videos or vlogs. And the reason why is, like I said, I have a big to-do list on my own, and then my wife's honey to-do list, and then the kids, they have their to-do list. Then my list just seems to get neglected. So finally I decided, you know what, before we're picking up a new car today, because we only have one car, we needed a new car. I know people are asking, well, what happened to the Hyundai i10? The Hyundai i10, like I said, was a disposable car, and it got to the point where it was worth more than it was fixing, and we had to get rid of it. I mean, this was done while I was indisposed, so I really had no control over it. But even after the car went through all that fixing, I think it was like $2,000 worth of repairs, it was still acting up. It was still stalling. It was still, you would be driving it and it would stall and stop. The engine would just turn off. So I said, you know what, just get rid of it. Don't spend any more money fixing it. So fortunately, we were able to recoup the money that was spent on fixing it. So we spent $2,000 fixing it, and it was sold for $2,000. Now, it was working, but it was just temperamental. You never knew when it was going to stop working, so we couldn't do that. And at that time, we didn't need another two cars for the boss to be dealing with. So we just said there was a lot of people that was actually interested in it. We could have probably sold it for more, but it was a matter of convenience. It was someone that we could work with really well in terms of finding the highest bidder at the time. I mean, you could always sell it for more, but that wasn't what we were trying to do. We just wanted, convenience was more important. So that's what we're going to be doing. So now that I'm out, we need two cars. The Fortuner is quite old. It's 13 years old already. So it might have reliability issues. I mean, it's running well right now. I've never had any issues with it, but it's just for safety's sake, we need to get a second car. So picking that up. And then what happened to the other car? Well, the police have it, and they've been using it for their own personal use. Well, how do I know? Well, because back even then during my inquest, where they take me to settle formal charges within the law over here, it's like you have 3 days where they take you to an inquest where the public prosecutor will tell you what the formal charges are against you. And when I was taken there, the complainants were the police and the complainants were there, and I was taken there by the Special Police Service. The police themselves were using my car to take themselves and the complainants to the inquest. I repeat, they took the car because they say it's part of evidence, which is, of course, an excuse. But when you're taking a car for evidence, it doesn't mean you're allowed to use it for business purposes. It doesn't mean you're allowed to use it for personal purposes. And that's the law. It's evidence. They're not allowed to touch it. Anything that's evidence, you're not allowed to use it for both personal or business use. You can't be saying, oh, we're taking this car and we're going to use it to take the complainants. Why? Why are you taking it? Why? Because you don't have a car, or yeah. And this is much nicer. This car is brand new. It's got air conditioning. The car we would use, it would be shaking, and it would be a government issued. It's not as nice as this car. Well, that's the reality here in the Philippines. And that's why I always kind of emphasize. I'm just checking if I'm still using the same phone, because I don't know if I'm too cheap, or because like I said, I don't want to spend another $500 on if this works, then great. If it's not, I'm just going to break this camera in half because it's been 3 days, but I'm using the internal memory instead of the SD card. I put the SD card in here, and that might be the problem. So I tried to have it read directly into it, and it was still corrupt. So I'm hoping that this video turns out and it's not corrupt. If it does, I'm gonna have to redo this thing all over again. But anyway, back to what I was saying. This is the reality. Of course, there's the law. You can't use any evidence for your own personal business use, but the police are going to do it anyway because they can. Why did they do it? It's not whether it's against the law or not, whether it's right or wrong or not. It's about I do it because I can, regardless if it's against the law or not. That's just the stark reality of here in the Philippines. Why? I can go into all day why people do the things they do here. I mean, it's culture. It's people over here are just victims of their circumstance, of their environment. I repeat, when you're just a victim and you're just a result of the environment, then you're just pre-delegated to whatever that environment is. So in this situation, their environment is, okay, we have no car to use, the government or the government issued car is not up to par. And then there's this car, we have the keys, it's brand new, so we're going to use it. Are we supposed to not use it? Yeah, we're not supposed to not use it, but who's going to complain or who's going to care that we're breaking the law and we're using the evidence for both personal and professional use? Who? We got the guns. Anybody who complains, everybody knows the culture over here. I've already pointed out that they're going to make it a big problem. So it gets to a point where it's the culture of, what's the word I'm looking for? Impunity, that they can do whatever they want because we carry the guns here and we're the law. And if you file a complaint against us, I finally figured out what the word is for these. Here's a PG. It's nubs. You see these little nubs right here? While I was in prison, I couldn't get rid of the nubs because I wasn't allowed to have something sharp. So I put this together while I was in prison, and it has a lot of nubs. Unfortunately, a lot of the nubs were undergated, so you didn't see it. But anyway, I was just looking at it and I said, hey, what's the word I was looking for? Nubs. All right, so back to what I was saying, the reality over here. Yes, there are laws, but laws fall into second priority when it comes to the immediate needs. It's like I always say, the people just live for the now and what they immediately need. And it's like, okay, they immediately need a car. Well, why use a beat up car that's issued by the government? I have this. When you can have a nice car. So, hold on, let me check. Let me test if this thing is playing properly. Okay, so far so good. It's working. So we'll work with that for now. It's like 7 minutes and I tested it, it's replaying. It's fine. So we'll continue. So, like I said, when people are living in the now, or people are, their immediate needs of their environment is the priority compared to what's going to happen tomorrow or next week or even next month. So you're not worried about that when you have pressing immediate needs right now. So part of their immediate needs was using my car, the new car, for both personal and at some point, there was a point where I thought, man, I think maybe that car was cursed. But I mean, it's just a car. But they used it, so I hardly got a chance to use it. I just picked up the new car at that time because the i10 was acting up, and I got enough support. Thanks for the people who supported it to get a new car, but only to be used by the police ever since. And what I'm gonna do about it right now, that's another issue. I mean, carnapping here in the Philippines by the police is another issue we'll talk about another time. That's very common. That's how they take a lot of SUVs, and it's pretty common knowledge. So I repeat, of course, not all police do that, but there are some that do. So I have to always do a disclaimer. Not all police steal cars. It's just in my situation specifically, they do. They carnap and they use it for both professional. I mean, if I look at, I have records that say that it's brand new. I bought it that same week, and if there's like 100,000 miles on it, well, then we got some serious issues if we can even find it. So anyway, I think the biggest problem of that car was it was paid cash, so there was no point that it was going to be repossessed. So that was kind of unfortunate for me. I mean, normally paying for a car for a cash is good, but not in this situation. Here in the Philippines, what's normally good can work out very normally bad for you. I mean, but so I mean that's spilled milk. It's you have to move on, and and well, what I'm going to be doing today is picking up a new car. Am I going to be vlogging about it eventually in the future? But right now, like I said, I got some unfinished business with the police. And the first thing you're probably saying, oh, well, I thought we discussed in the last discussion that you've said that it's not a good idea to file a case against the police. And yes, I absolutely agree with you. I'm putting myself in danger. But I'm not the problem over here, because the police, not only, I already showed documentation that the police not only filed one case against me, not only they filed 2 cases against me, they filed 3 cases against me. So clearly that states for a fact, not an opinion, that the police is not going to stop unless I'm in prison or I'm underground or something. It's just saying that they're not. This is, and the reason why, I mean, I could show you again for the people who haven't seen it. This is the number, the reason why, one of the many reasons why this document, and I have several documents, that this is this is 475,688 pesos and 59 centavos. I repeat, 475. So almost, they have 500,000 reasons why. The police have 500,000 reasons why this document and me need to disappear. So that's why their plan was to bury me in court for the next 5 to 10 years on technicalities, and the process is so freaking long that for them 5 to 10 years is perfect. And in my situation, it was only 3 years. And the reason why it was only 3 years versus 5 to 10 years of burying me, like I said, the police were relentless, and this is the reason why, is because I am innocent, period. Now, you can say whatever you want, and you can accuse me of whatever you want, but the judge still has to decide, and we still have to have evidence of, remember, I'm innocent, and it's the burden on the prosecution to prove that I'm guilty. So, but in my situation, there's a saying where saints are all guilty until proven innocent. I repeat, saints are all guilty until proven innocent. Do I fall in that category? I don't know, but I definitely am in the category of I am guilty until proven innocent. I think part of it is the crimes involved. They're so heinous that people want to believe that a person is guilty right away. Why would you accuse somebody of those things if it isn't true? I mean, they're so heinous. Why would you accuse somebody? And here's the reason why. This is the reason why. 500,000 reasons why. Over here, and people are very simple. They're driven by, I mean, of course, hunger, biologically, sleep, sex, and then there's money. I mean, money means life over here. And here's 500,000 reasons why. And, what law will they break to do it? And if the police are watching this, they know. I mean, they know. I'm not saying anything that they already don't know. So this makes it a very dangerous situation for me and my family. This number right here and other documents that I possess. And I know the first thing you're going to say is, well, don't file a case against the police, then they won't bother you anymore. And I said, that's wishful thinking. Like I said, as long as this exists, they're going to be relentless like they were before. And I have to be mindful of that. I repeat, you have to accept the fact that it's better that they're not going to give up versus wishful thinking that they're going to give up, because you're going to put yourself in a very dangerous situation. But like I said, the judges are the one that decide, and everybody will have their day in reckoning. Every dog has his day, and eventually If I keep fighting and surviving long enough, I will have mine. And maybe, who knows, maybe I'm already starting it. But the fact that I am vlogging is a blessing in itself. So when we're talking about judges, let's go back to this document over here, because it's going to be, I have to set it up. It's going to be, in terms of the situation, I think the biggest problem people are having is accepting my innocence, even though 3 judges have already made their decision. I repeat, not just 1 judge, not just 2 judges, but 3 judges have already made the decision whether I'm guilty or innocent. So, but before we get into that, I think that the biggest struggle that people are saying is that, oh, because I have money or I paid them off. And there's nothing further from the truth. As you could see over here, you know, it became a problem for me. That instead of helping me, the money hurt me. So the first thing people was saying, number one, is I won because I bribed somebody. I bribed the judge. Which is nothing further from the truth. And number 2 is I won on a technicality, and I wanted to show you where I couldn't win on any technicality, period. So the first one is money. I already showed you that the money was already working against me, and that it's when people say, "Oh, I paid him off with money." I mean, everybody makes it sound so simple. Once you have money, all your problems will go away. There's nothing. People want to say that there's nothing more ignorant when people say that. When I hear people saying that, you know, it's like, especially after I experienced it personally, people say, oh, he just paid it off. There's nothing more ignorant. And why people would say that, to show their ignorance, we have to ask why. Are they insecure? Are they jealous? I mean, that's probably the number one reason why a lot of the people would say those things, is when somebody's ignorant and jealous and insecure. I mean, if that's your problem, I guess I don't want to really dive into that right now. I could. It will take me like 8 hours to talk about it. But I just want to address that you can't just say things like that, because these are people's livelihoods, that you can't be, you know, they could, it's a serious problem. You can't make statements like that without any evidence. It's considered libel and slander. I repeat, you know, then the people, the officers of the court, the judges, the lawyers, if you're saying that, that's libel and slander without any proof of it, that you're saying that they got bribed or they were corrupted. Nothing further from the truth. Anyway, I'll give you, if I give you an example, I mean, lawyers over here, like I said, I had 2 lawyers. My first lawyer, that's another story in itself. Why I had 2 lawyers, because the first lawyer, I didn't fire him. He quit. I repeat, he quit because the kitchen got too hot for him, because he was unethical, and it caught up with him, and he had to excuse himself. And the boss had to scramble for another lawyer. There was a point where I had no lawyer because the first one was so unethical. Unethical lawyers, that's kind of redundant. Let's stick to the fact that all the people over here have gambling problems, especially lawyers, even lawyers. I'm not saying all lawyers. I'm just saying, generally speaking, specifically with my lawyer, he had a habit of the casinos. They knew him on a first name basis, and also chicken fighting. He was very famous in that scene also. So any money I gave him, let's say, for argument's sake, I give it to him for bribing purposes, as people are accusing me of. I can give him 1 million pesos. I can give him 10 million pesos. Hell, I can give him 100 million pesos. Everybody, it's pretty clear, if you got a lawyer that's a gambling habit, that's only 5 minutes in a casino. It doesn't matter if it's 1 million. It doesn't matter if it's 10 million. If it doesn't matter if it's 100 million. That's only 5 minutes in a casino. Well, how do I know? Well, proof that he had to let me go. Did I do it? Did I bribe? Did I do it? No, I didn't. But I already knew I don't need to do it to know that that's what's going to happen. As it was progressing, and they're like, oh, well, Ben was only, isn't that libel and slander? No, that's pretty common knowledge that he had a gambling problem. And if I did give him money, that's where it would go. And that's the last thing I want, is to give money and it would end up gambling. So why would I do anything that stupid? I repeat, I couldn't give any money, even if I did have the money, or even if I did want to, because I knew exactly where the money was going to go. It was going to be wasted, and it was just going to be used for gambling. When you have to understand, here in the Philippines, when you give somebody money and they're holding it in their hand, the first thing they're going to do, and it's for something else. For example, it's for tuition, it's for electricity, it's for medicine. It's never going to go to tuition. It's never going to go to electricity. It's never going to go to medicine. And it's definitely not going to go to any decision that for the courts to make that will go into my favor. This is why we're going into this document over here. So none of that will happen. So I didn't have that option. There was no way I would be throwing away good money after that. It was clear to me with the first lawyer I was dealing with that this was not going to be. So I'll go into more in detail about how that is the dumbest, most ignorant, most insecure thing anybody will say about my case anyway, about money. Okay, so first thing people will say is money because of this and that, and I already clearly, you can give money if you know Vito Corleone, and I've said that before, then the case will go away. But there are no Vito Corleones over here. I repeat, you're just watching too many movies. And you think that this, because you watched the movie and this happened to this movie, or you heard this rumor, or you heard that chismis, or you heard that story, all of a sudden you think it applies over here, where the reality is so far distant from what your perception is. I repeat, reality is not something that you have any experience with like I do. Okay, I specialize in reality because I experience it every day. You just hear stories and you watch too many movies. So back to what I was saying is, so the next one was, I went on a technicality, schmechnicality. Okay, so that's the first thing. No, nobody wants to believe that I could actually be innocent. That would be too easy, or that would be too dumb, or it would mean that you were secure, right? Even though 3 judges have already decided, you're still going to say, oh, he's guilty, but he just, because of money or because of technicality, that he was acquitted. So let's get into that technicality part. And what I have here is a document for motion for inhibition. I repeat, motion for inhibition. I go, why? Because one of the judges, remember I have 3 judges that I had to deal with, or that I had to be part of this dance with. This judge, let me set it up for you. He scared the heebie-jeebies out of me because, let me give you his background. I actually Googled him, and he was actually like the top 1% of the bar exam. Like, they do percentages, and he was like 97.1% so this guy is intelligent. I mean, you could make arguments, oh, well, that the bar exam in the Philippines, where it's still an exam, he still has to compete within his peers, and to be able to achieve 97.1% of a national exam is very impressive. So it means this guy is very smart. He's very intelligent. He doesn't make decisions. And some people are just born smart, and they're naturally talented to be intelligent. And this person clearly was, after going through law school and passing the bar exam. So this judge is smart. Okay, he's not dumb. He's not gonna. So for any of you who are saying that, oh, he just took a bribe, smart people don't do that. They don't need to do that. Next is that he's also a dean and a professor at a big law school here in the Philippines. I repeat, not only did he pass the 1% of the bar exam of, and this is all public knowledge. I'm not making it up. I could probably pull it up on Google, but I don't want, you just have to take my word for it. There's no reason for me to lie about a judge's credentials over here. Top 1%. And he's also a dean and professor of a big law school over here. So, and not only that, he wrote a book on law. So he's a professor, he's a dean of a law school, graduate out of it, and he also wrote a book on top of that, published a book about family law. I think I looked it up. I just, before I did this, I was going to do a whole presentation of this judge, but I decided against it because I mean, all this is public knowledge, obviously, but it was just something I decided to go against. It's better, it was one of these situations, it's better to not to know who he is versus to know who he is. I mean, even though he is a presiding judge, no, I didn't think I want that extra attention. Anyway, so I decided to keep his name out of it, and even though it's all public information, you're gonna have to look it up yourself. But even if you really want to know, but I'm just giving you his background. So this person, so based on that, this person, and he's a judge, and so ethics is very high with this person. And then, so I just want to let everybody know what we're dealing with over here. It got to what scared me was that his judge is supposed to be impartial. Well, he was doing things that weren't impartial. Well, I'll give you an example. I wish I have paperwork, documentation somewhere. I got a lot of, but that said, one of the things he did was he issued. I have complainants, obviously. He issued an arrest warrant. I repeat, an arrest warrant for the witnesses of the prosecution. Can you believe that? I've never heard of that, or no one's ever heard of that. He issued an arrest warrant. What happened was there was a misunderstanding about the dates of the witness of the prosecution didn't show up. So about the dates, and the judge said to make sure that this doesn't happen again. He really wanted this case to go on, to continue. So he says for this not to happen again, he issued an arrest warrant for the next hearing. Because if this happens again, the hearing had to be reset. But it was the police didn't bring the witness. Then he was gonna issue an arrest warrant, something for the police to force or just to make sure that the trial continued. So I said, so that's one thing. And also, because remember, they didn't have a search warrant to use to open my electronic gadgets. We filed a motion for to block the evidence that didn't have any search warrant. I repeat, block any evidence. Well, if they wouldn't have a case, if they didn't have any of my computer information, electronic information, they're saying, well, that's all the evidence is in there. And if you say that we didn't have a search warrant and you blocked it, then we wouldn't have a case. So he said, okay, this judge says, I'll allow it. And he said something very scary at the time during this, all this was going on. I mean, I was in a state of shock, anxiety, attacks. It's like worst case scenarios, fears, years and years. So so he issues an arrest warrant, unheard of. And the other thing that he said that was scary to me was he said he couldn't dismiss this because of the pressure that was put on the technicality, because there's a lot of external pressure. I don't know what those external pressures are because I'm not privileged to them. What kind of, but he did mention in open court that because this was a certain matter. I think he might have said police matter, but there was something that he said that made me think that, oh, okay, he's being pressured. A lot of it has to do because of the media pressure. There was so much media pressure, so much attention on this case when it first happened. The fact that I was a dual citizen, the fact that this was such a heinous crime, the fact that it was qualified because the complainants are minors, and that it was more than 3 people, and then it got so much media attention that he was under the microscope. He was that so many people, every time I would show up to these hearings, it would be like a parade of dignitaries and VIPs from the law enforcement that would show up just to watch the circus. It was that I want to say embarrassing, and my attorney, the first attorney, had to point that out. I go, who the hell are these people? Are they witnesses? And they're like, no, they're just part of the police. Well, then let's make a note of it. So and so police officer, major so and so, colonel so and so are here. And for what purpose, we don't know, or they're not part of the prosecution. They're not part of the witnesses, so they're just there to just there to watch the circus. So there was a lot of pressure, a lot of for this to continue. I don't want to say pressure to convict me, but there was definitely the pressure of the judge, because of high ethics and high morals. That's what I was just depending on, that he was going to be able to see through all this fluff. So all this pressure, okay, he's still a judge. It's his court. He decides, not the pressure from the police, from the government, from non-governmental organizations or governmental organizations. It was his decision. So that was the only thing I was hoping for. But it was all coming to kind of a head, because every decision he made was against me. And I wanted to give you an example of what I was working with, how what do you call that, difficult it was for me. And that's why we got to a point where this judge, we lost the fact that all his decisions and actions were so biased, that we finally filed a motion for inhibition. I repeat, we finally inhibit what? Well, we filed an motion to inhibit the judge. So let me reset this, because it can only handle, I think, 30 minutes. So finally filed a motion for inhibition to inhibit the judge. And they go, and you have to ask why. And it finally came to a head. And this was the straw that broke the camel's back. So what I'll do is I'll read this motion to you, and I can see whether you want to, what your opinion is. Everybody is allowed to their own opinion, but what I usually like to do is stick with the facts, stick with the black and white. So let's read this off. It says, this is the motion for inhibition, and well, I'll just read it to you. And it's pretty much res ipsa loquitur. It speaks for itself. Accused through the undersigned counsel. You know what? I use that word a lot, that Latin phrase a lot, and sometimes I don't even think I'm using it properly. But it's supposed to be the main flavor or the message of the Latin phrase is it speaks for itself, but it's not really used. It's usually used in kind of a in legal situations where who's at fault. And this one, it's not really about who's at fault over here. It's about there's no need to explain if I just read it to you. So the Honorable Court issued an order denying the undersigned's urgent ex parte motion for resetting, ordering the waiver of the right of the accused to counsel and the waiver of the right of the accused to cross-examine the prosecution witness to wit. So it pretty much that says I was denied my own counsel of my own choice, and I was denied to the right to cross-examine my accuser. So that's everybody's God-given legal right. Which no one can take, no judge, no God, nobody in the government can take away from your right to your own counsel of your own choice, number one. And number two, you can't be denied the right to cross-examine or to face your accuser. But I was denied that. Nevertheless, there is before the court an urgent motion for resetting filed by the counsel for the accused. My attorney is actually my second attorney, which is he's good. but you know, he has his pros and cons, which I'll go into it. But good enough is what I'll say right now. The same is hereby denied, considering that the hearing of this case has already been unduly delayed with already a couple of warnings to the regular counsel of the accused. So they're saying, oh, it's been delayed. That's why they wanted to continue it. After having advised the accused of the consequences of his decision to not to have presence of regular counsel, or in the alternative, not to get another counsel, or to refuse the representation of the POW lawyer, he is deemed to have waived his right to counsel at this point, also considering that he cannot cross-examine for himself. He also deemed to have waived the right to cross-examine the witness. So here we go. We go into the grounds for inhibition and discussion. For a better understanding and appreciation of what really transpired, the court was saying that this has been delayed. This is the fourth setting, actually. So they're saying that it's been delayed 4 times, and the judge is saying that you had plenty of chances to continue this trial today, and we're going to continue it whether you like it or not. And since you don't have a lawyer here present, we deny you your right to counsel, and we deny you your right, because he's saying we had 4 chances to correct this, which is furthest from the truth. He's saying that we had 4 chances, which is not true. And this is the black and white letter Y. It's transpiring the previous hearing. So this case below is the chronological sequence of events leading to the unconstitutional, biased, and erroneous order dated of the presiding judge, which clearly shows his principles, his prejudice and disdain to the detriment of the accused. I repeat, his prejudice and disdain, or you could say bias, to the detriment of the accused. The first setting for the cross-examination, because it was a time for us to do a cross-examination. The prosecution the complaining witness was on, while undersigned counsel was still on his way. My lawyer was on his way to the trial, as you can see here, to the court, and without concurrence, without warning, the hearing was reset. I repeat, so you talk about four chances. Well, the first chance was it was reset. My lawyer was on his way to the trial, and he got a message saying that it was reset. And the reason why is the non-availability of the assigned public prosecutor. I repeat, non-availability so that was documented. The first one, reset. Well, that's one of the reasons why these hearings take so long, is it'll get reset and you have to wait another month or 2 months before you get another hearing. So as you can see, the non-availability, and that's all documented here. So this was relayed by my wife, who happened to, she was in court. Upon learning that it was reset, was rescheduled on a date which the undersigned counsel is not available due to a previously scheduled hearing before RTC court. He had that date that he was given, he wasn't consulted for, and so the undersigned, and immediately my wife told him to tell the court and the staff that he has a schedule that day. So the wife of the accused was told by the branch clerk of the court to tell the undersigned to just file a motion to reset. So we had the motion reset to appear in the previous scheduled and an equally important case before branch 60, and this is another case. So let's get to the next one. So the motion, the undersigned also requested that the hearing be reset in its earliest level. So he gave a bunch of dates at the motion to reset of what's available, and like I said, with this judge, the motion to reset, because he obviously gave a schedule, and this schedule that he had was already set before the judge set the schedule. So it was a conflicting schedule, and he gave other available options. He gave a bunch of available dates, but this judge denies it, completely denies it, says that's your problem, not mine, which is not something that judges would normally, of course it's at their discretion, they're the judge, but most judges would say, okay, then they'll use this date. But for some reason, this judge didn't want to accept. This was the date that was set by the court. So the second setting for the cross-examination, here we go. Second again, the hearing was once again reset because the assigned trial prosecutor was reportedly not available. So there was 2 hearings that got reset, which we had nothing to do with. It was because the prosecutor wasn't available. Okay, that's not our fault that the prosecutor was. Second reset, prosecutor was unavailable, but we're still getting blamed for it. The Honorable Court still possessed reset, so we had another reset hearing. And that hearing, he also is not available. So he gave another bunch of dates. Says, okay, I'm available this date, I'm available that date. He says here, it would be physically impossible for the undersigned to do so because he was already previously committed to an equally important case before, and he gave supporting document. These are the dates. Please don't schedule a trial during these dates where I have a trial in another court. That's what he said. And then during the third, this was my fault, or I was part of it. During the third hearing, the Bureau of Jail and Management and Prisons didn't bring me to court. So we were all set to go that day, but I wasn't brought to court. It wasn't my fault. So the first 2 hearings where the prosecution didn't show up. Third hearing, the prison didn't take me to court. So the judge saying that the motion for resetting by undersigned counsel was ordered to have been rendered mute and academic since I wasn't brought there in the first place. However, despite the motion was filed specifying available dates, when the next available date is, once again, they keep assigning him to dates that he already has a schedule for, that he already gave him a list, and he gave him a list of available dates. So here we go. We go to the fourth. So this is basically saying that he can't make it to this fourth setting. So on the fourth trial, or on the fourth attempt, for the cross-examination of the prosecutor's complaining witness, the Honorable Court issued above order denying the motion to reset. So the judge wanted to continue the case, even though I didn't have a lawyer. So the judge wanted to continue it, even though I didn't have a lawyer. So motion for resetting is by undersigned is found on a meritorious ground. We have like legitimate reason for him not to, because he had another trial, and so he gave all of these dates, and the Honorable Court will set the hearings and in the other dates where his undersigned is not available. So and then say it's payment. So it's just basically saying that. So this is what happened to that day. To make the matters worse, during the proceeding for the instant case, the judge unceremoniously denied the motion to reset filed by us and made rulings and uttered statements which are not in accordance with the law. I repeat, they're not in accordance with the law, and expected and required from a presiding judge as follows. So here's the court. Okay, so here's a sample of the transcript. It says, court, okay, so your counsel is not here. Okay, so you also do not have new counsel. So this court is now appointing you the lawyer of public attorney's office. PAO means public attorney's office, to act as your counsel for today's hearing. What do you say to that? And me, I say, I decline it, Your Honor. I exercise my right to have private counsel. So the court says, or the judge says, so you're refusing? And I said, yes, Your Honor, I'm refusing. Okay, so the judge says, okay, to show in the record that the accused does not have his regular counsel because he filed a motion to reset and the judge denied it, he hasn't secured a new counsel, and that he's refusing the service of the PAO. I mean, I'll get into reason why we didn't do that. We had other strategies ongoing. Next point before this court is an urgent motion for resetting. And so he says it's denied. The motion to reset to a schedule was denied. So he says he gives me 30 minutes within which time to think about it. You can call your counsel, new counsel, or engage the services of the spouse. So he gave me three choices. I got 30 minutes to decide. Okay, because he denied the motion to reset, so the trial was going to continue, even though my lawyer was at another trial. You can call your, so I can call another lawyer, which is going to be impossible to do in 30 minutes, especially since I'm in handcuffs. So that was kind of he just said it as to be academic. You have 30 minutes to get another private lawyer, or if you don't, you're going to have to use the services of the public attorney's office. So you have a right to an attorney, but he's denying me my right to my attorney of my choosing. Otherwise, you would be deemed to waive the right to cross-examine the private complainant. This case has been has been delayed with already a couple of warnings. And he's saying warning to us when the first three was obviously the reason why was the prosecutor didn't show up the first two, and the next one was the prison didn't bring me to court. What was the reasons why? I could probably get into that, but they didn't bring me. I just wait and hope they bring me, and they didn't bring me, and I was wondering why they didn't bring me. What were all the reasons why? And you would have to ask them, the Bureau of Corrections, why. And somebody's gonna say, "Oh, because you paid them off, did I bring that?" That's like, how am I supposed to do that? So none of that. So I said, "Yes, Your Honor." So I mean, but that's what people were thinking, and I don't know why they didn't bring me. I always go when they bring me. I just follow whatever. If they bring me, they bring me. I can't sit there and complain and says, "Hey, I have a hearing today. Can somebody please bring me to court?" And unless they have the paperwork that says to bring me, they're not going to bring me. So I remember that day now. It's like when I asked hey, I have a court hearing today. I have it on schedule. And they said they never received an order. We have no order to bring you to court is what their reason was. So they're not going to bring me unless there was an order to bring me to court. At that date, there was no order. Why? Maybe the secretary or the administration didn't send the order, and that happens. I mean, you got government workers. Sometimes they're busy and they forget things. They think they did it and they didn't, and the day came. And so what? Then we'll just reset it another time. No big deal. Big deal to me because I have to wait in prison. So if your decision is still the same, you can't cross-examine the private complainant anymore. So the judge is saying if you don't take the POW, you're denying your right to cross-examine your accuser. So the judge asked, "What's your decision?" My decision is I exercise my right to private counsel of my own choosing. And I think he said, do you like the public attorney's office or not? I think that's what he said before. I would have to go to the original transcript. And he says, "I'm not saying I don't like the public attorney's office. I'm just saying I'm sure he's an excellent public attorney. I'm just saying I just choose the private counsel that's been with me from the beginning of the trial, the second one anyway." The judge says, not that you don't want him personally, you just don't want him to be your counsel. We don't take things here personally. Ha ha ha. Let me just ask the POW. So this is what the public attorney's response to that is. This is the public defender's response to the judge. Okay, he says, the judge says, "Are you ready to defend the witness?" And the public prosecutor says, "Given the fact, Your Honor, that I just entered my appearance today, it would be best to reset the hearing, Your Honor." That's what he said. "I'm not ready to defend him." He tells the judge is assigning him to me against my will, against my rights. And I've already on record said that I decline him, and he's asking him, "Are you ready to defend him?" And this is what the public defender says. "I just made my appearance today, and it would be best to reset the hearing, Your Honor." And Your Honor says, "No, you were given instruction already." So he was already told that he's gonna be my attorney by the judge previously, even though it was reset by the prosecutor's office, and he already knew that we already set a motion and he was gonna deny it. And he told the public defender, "Hey, I told you instructions already before." I would have to say off record that he was going to be my attorney against my wishes. Well, we appreciate the efforts of the Honorable Court towards the speedy disposition of the instant case by offering the appointment of the counsel of the public attorney's office. The proceedings for the instance of the case, the accused has categorically manifested his desire to be represented by a counsel of his own choosing. The Honorable Court turned a deaf ear to this manifestation of the attorney from the public attorney's office. But since he just entered his appearance that very day, it would be best to reset the hearing. The judge still wouldn't allow it. So this was the straw that broke the camel's back. We've had enough. This judge has always been biased and unfair with all his decisions. He's impartial, and now he's just blatantly denying my right to counsel. He's blatantly denying my right to cross-examine my accuser. So we said, time to motion for inhibition for this judge. So worth noting, stressing at this juncture is the glaring fact that the failure of the counsel for the accused to appear on the scheduled dates made by Monroe was never intentionally made to delay the proceedings. It is by reason of a previously scheduled hearings before, in fact, before another court, and then the other previous was reset by the prosecution. Was not available due to so the undersigned counsel did not intend to delay the proceedings of the instance case. This is very evident of the fact when the first motion for resetting was filed. Undersigned counsel immediately declared him an honorable court. However, despite stating the several dates available, the court wouldn't accept it, intended to schedule the hearings. So my attorney gave the court a list of dates that he already can't make it, and they intentionally, and these dates were made years before they made the date. So we have one judge saying, okay, my hearing is more important than that hearing, so even though it was already, that one was set before mine was, you're gonna have to show up to mine, which he couldn't do. So he was already committed to the other one, and this one had to be reset. Given the foregoing that there is no justifiable reason for the Honorable Court to insist on the appointment of the power lawyer to be the counsel for the accused, the statement of the Honorable Presiding Judge that the case has been particularly the cross-examination has been unduly delayed with already about a couple of warnings are no basis. So he's saying that the reason why the judge is continuing the trial because we delayed it has no basis, because the first two was the prosecution did not attend the trial, and number two, the prisons, the Bureau of Prisons did not have an order to take me to trial. So that was the first three. And this one, they scheduled it again where it was to a date which was he wasn't available. And if you give somebody a list of the dates where you don't have available and they still do it, I mean, then they're doing it on purpose. So this was. And then he gave it a list of available dates, and they still continued to choose the dates where he's not available. Then it was clearly we were dealing with somebody that was not impartial. That's what we're saying in our documents over here. Had the Honorable Judge set the hearings date on dates where the accused committed to be available, the accused would not have been deprived of his right to cross-examine the complaining witness through the counsel of his own choice. So here, the complete disregard and deprivation of accused constitutional rights by Honorable Judge did not end there. In the same proceedings, the following transpired. Accused me, I says, I want my right to cross-examine the witness by my private lawyer. The judge says, okay, so despite the manifestation of the POW, the public defender, he is ready to cross-examine, even though he just said he wasn't ready to cross-examine. The judge is saying he's ready to, even though the public defender just said that he's ready to cross-examine for the behalf of the accused maintains that he's not hiring the services of the POW. The court wants to explain to you that if the court gives its ruling, your cross-examination will be waived. So the prosecution says, that's the effect of your decision. The judge says, that's the effect of your decision. And as the accused, I understand. I just want to clarify that it's never my decision. I just want to put in record that it's not my decision. It's the effect of the decision. So the judge says, yes, if you understand that the effect of your decision is the waiver of your right to cross-examine the witness, And as the accused, I say I didn't say I waiver my right. I don't want them putting words in my mouth, and because this is official document saying that the judge is saying I waived my right, and I said I needed to clearly say I did not say I waiver any of my rights. The judge says that would be the effect. The court will consider it wavered. You see what I'm dealing with here? I just said that I don't waive any of my rights, but the judge says yes, but the effect says because you made your decision not to accept the public defender who stated that he's not ready to defend you, the court will consider your rights you waived your rights. Even though I say I didn't waive my rights, the judge waived my rights, and he's saying that I did it voluntarily. So that would be the effect. The court will consider it wavered. Prosecution says right now he doesn't have counsel. So this is the prosecution's statement to this. So right now his statements will not be, I'm not sure why it's cut off. His statements are not counseled. So I can't really talk, or I can't really make a decision because I have no counsel. So anything I say at that point would be considered not, or anything I say because admissible, or it doesn't have much say because I don't have a lawyer present in court. I declined the public defender who clearly stated that he wasn't ready to defend me. So even the prosecutor said, well, any of his statements are not counseled, so they can't be enforceable. I can't say, there's nothing I could say at this point is not going to be admissible because there was I have no lawyer at that time. So the judge is addressing me. So he says, the above formula clearly shows the bias and prejudice exhibited by the judge against the accused. Even the public prosecutor was mindful of my constitutional rights and the accused, and even made efforts to put on record that the statements of the accused were not counseled, yet the judge blatantly disregarded it all. To our minds, the case cannot be decided with impartiality and genuine justice, considering that even constitutional rights of the accused to counsel and to cross-examination the witness was ordered waived by the judge, despite glaring fact that the accused stated that he's not waiving his rights. Furthermore, accused was not even represented at counsel when these rights were ordered or deemed as waived. So it is with utmost respect and furtherance of the constitutional rights of the accused, we move for inhibition of the judge. So here's an example of the reasons why it's Section 1, when a judge is disqualified. No judge or judicial officer shall sit in any of which. If you have family members, you can't. So that's Section 1. A judge may exercise his sound discretion to disqualify himself for sitting in a case for just or valid reasons other than mentioned above. So but a judge could still exist. This is the main problem with this motion. The judge that will decide whether it's not another judge or another circuit or another panel that's going to decide. It's the same judge that we're asking, can you please inhibit yourself from sitting in our trial because you're biased? And so you're probably asking, well, why are you asking the same person? Because obviously he's going to deny it. And our strategy was that in case the decision goes wrong, that we were going to file for an appeal, and an appeal can take 3 to 10 years to finally be considered and decided. But we had no choice. We had to go this direction anyway because we feel like that we were losing the case because the judge clearly was making decisions that were scaring the daylights out of us. Every decision he was making was like, nope, sorry, against you. So we were scared of the final decision. Canon 3, impartiality. Impartiality, judges shall perform their duty without favor, bias, or prejudice. The judges here can conduct court, enhance confidence, and impartiality, just reasonable conduct. So these are just sections explaining judges shall disqualify themselves. So the judge has to accept our inhibition. From participating in proceedings which they are unable to decide the matter of impartiality, or in which it may appear to a reasonable observer that they are unable to decide the matter of impartiality. So we wanted to show, in case we have to go on appeal, that this judge was impartial, that we could win, then there's your technicality right there, that we could win on a technicality. But obviously it didn't get to that point. But I just wanted to show you the kind of judge that we were dealing with, that he wasn't going to make any decisions to favor us, if anything to my detriment. But even then, the decision was still the final decision. But before, when this was going on, it was up in the air. In light of foregoing, it is therefore the most respectfully prayed by the accused or the undersigned presiding judge disqualify from hearing the case for the incident to be re-raffled to a new court. So we're saying the new date, the new trial date should be reset and re-raffled to another court with a different judge. So a judge may not be legal from sitting in litigation, but when litigation is made of record that he might be induced to act in favor of one party or with bias or prejudice against the litigant arising out of circumstance reasonable, capable of inciting such a state of mind, he should conduct a careful self-examination. He exercise his discretion in a way. So we're asking the judge, please excuse yourself, because your biasness is just not happening here. So we're therefore be raffled motion, blah, blah, blah. So that's pretty much the end of our motion right there. Respectfully submitted. So if you look over here, he already submitted like all these dates that where he wasn't available, and there's like a second page of this where all these dates are where he already submitted to them that these are trial dates that he already is committed to. And there's another page because this one's just for the prosecution. It's pretty long. This one in Angeles City over here, it's for kidnapping for ransom with homicide. So that's one count. There's another one for kidnapping and serious illegal detention. So we got homicide, kidnapping, and then we have one for carnapping. So this case had a long list of trial dates, and he already submitted it. So this is part of the supporting document. And we also have other supporting documents saying that we did not reset the first three trials. The first two was the prosecutor wasn't available, and the second one was there was no order to take me to the hearing. So finally it came to the fourth trial, which he clearly said over here in the supporting document, he has trials on these dates for this serious kidnapping, ransom. What happened with that? I don't know yet. Usually when it comes to these kind of high organized crime kind of situations, I don't really want to get into right now. Okay, so far so good. I just transferred the first wave of files into the computer and it's working. So far I'm using the internal memory of this cell phone. So I'm going to go and continue the vlog here. It's gone long enough, like an hour already. But I just wanted to give you the complete transcript of the trial where we had no choice but to decide that this judge was biased. And if he decides to rule against us or to judge against us, or it's unfavorable and we have to go on appeal, then we use this as a strategy. We motioned to inhibit him because he was biased, and hopefully we could win the appeal. But we were trying to prepare for the future, which is a scary thought, thinking, considering appeals could last anywhere from 5 to 10 years. You could win, and if you won the appeal and you were wrongly in jail for all those years, then you get this what's called a daños, which we are paid money for being in jail. But the problem with that is you're paid only like 20 pesos a day. I repeat, 20 pesos a day. So that's not worth going to prison for. You'll get 20 pesos a day for the next 10 years, but at least it's something. It's better than nothing. It's probably your argument. But anyway, let's get to the court says the judge says called the case. The interpreter says for the initial presentation of prosecution's evidence, criminal case, blah, blah, blah. So the prosecution says, good morning, Your Honor. For the government, public attorney says, good morning, Your Honor. I have talked to the accused in the case and he refuses the services of the public attorney office, invoking his right to counsel, Your Honor. That's my right. And then the court says, the judge says, okay, see your wife here, ma'am. To the court, during the last hearing, you were instructed by the court to deliver a message to the lawyer. So number one, for him to appear for you to secure another lawyer. And then third, the public defender said you inform your lawyer. And my wife says, yes, I did, Your Honor. So the record show that the wife the accused, what's your name? She says her name, full name. So the court says, okay, so your counsel is not here. Okay, so you're also going to have a new counsel to this court. So this is the second call after the 30 minutes we were allowed. So appointing the lawyer. So we were actually saying, okay, go ahead and try to appoint and try to waive. So this is kind of our way of trying to set up the appeal by going through with it for today's hearing. So what do you say to that? And I said, the accused, I decline it, Your Honor. I exercise my right to have private counsel of my own interest. So you're refusing. Accused says, yes, Your Honor. Judge says, okay, so just to show you in the record that the accused does not have this regular counsel, he has secured new counsel, and that he's refusing the services of POW. Next point before the court is the motion to reset filed by the regular counsel for the accused. So the same is hereby denied. So he denies our motion to reschedule. You have 30 minutes within which to think about. You can call your counsel, new counsel, or engage the services of the public defender. Otherwise, you'll be deemed to have waived your right to cross-examine. So deemed to waive my right. So this case has been particularly the cross-examination has already been unduly delayed with already about a couple of warnings. So to your regular counsel. So he's saying that he already warned my counsel before, so 4:30 will call and say, do you understand that? Yes, Your Honor. So as your decision is still the same, you can't cross-examine the private complainant anymore. Second call communication. So you're not sticking to your decision. So you're still sticking to your decision not to present a new lawyer to get your powers. He doesn't want. So the court says he doesn't want you as his counsel. Attorney says, so you decided that you're refusing the services of the POW. Accused, I say, I didn't say that. It's your decision. Attorney says, it's your decision, not mine. Court says, judge says, what's your decision? My decision is I exercise my right to private counsel, and I'm not saying that I don't like him. Court says, not that you don't want him personally, you just don't want him to be your counsel. We don't think so. Let me ask the POW. So I have directed the POW for the past 2 orders to get ready for this case. For this eventuality, you're ready for the cross-examined witness. It says, also given the fact, Your Honor, that I have entered my appearance today, it would be, so this is the public attorney's office. Given the fact that, Your Honor, that I have just entered my appearance today, it would be best to reset the hearing, Your Honor. So the judge says, no, you were given instruction. And the public defender goes, yes, you're right, Your Honor. I think twice. Then, yes, Your Honor. So the public defender was strong-armed or twisted his arm. So, okay, so POW lawyer is ready to defend. So you still refuse? Yes, Your Honor. After hearing that, yes, I definitely refuse this public defender. So the judge says, okay, I'm asking it for you to be on record. Prosecution says, by the way, can you understand Tagalog? I said, yes, of course. It says, yes, Your Honor. Prosecution says, okay. Accused says, I want my right to cross-examine the witness by my private lawyer. Court says, okay, so despite the manifestation of the public defender, the witness on behalf of the accused maintains that he's not hiring the services of POW. The court just wants to explain to you that if the court gives its ruling, your cross-examination will be waived. That will be the effect of your decision. Do you understand that? And I said, no, that's not my decision. That's the effect of your decision. So I said, so court says that's the effect of your decision. I understand. I just want to clarify that it's never my decision. I just want to put on record that it's not my decision. It's just the effect of the decision. Court says, if yes, you understand the effect of your decision, the decision is the waiver of your right to cross-examination. Accused says, I didn't say I waiver my right. Court says that will be the effect. Considered will be you waived your right. Prosecution says right now he doesn't have counsel, so right now his statements will not be, his own statements are not counseled. Court says the court is okay, Your Honor. So after having advised the accused the consequences of the decision to have, number one, the presence of a regular counsel, alternative, he seems to have waived the right to counsel at this point, and also considering he cannot cross-examine for himself, he is also deemed to have waived the right to cross-examine the witness. In view thereof, the testimony of the witness is hereby considered completed and terminated, and before the presence of the court is dispensed. So the next point, fiscal, is do you have another witness? Yes, we have, but since it's already late, we'll continue. So it's already 5:10. Considering today, so you can reset to 5 to 2 o'clock. So you understand what I said? Call your counsel, I have another, I'll accept the service. And so I said, yes, Your Honor. Make it on record, the court explained the accused appears in the next scheduled hearing or he has another counsel or accept the services of the public attorney's office. You understand that? I said yes, Your Honor. So the order, blah, 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 blah. The accused was given 30 minutes within each to think about this counsel after having advised the accused counsel. So this is basically summing it up. So therefore, the witness is completed and terminated. So there was no cross-examination. So it's reset. So what I'm saying here is that I did not win on a technicality because, as you could clearly see, this judge wanted to continue. And the worst part about it was that my right to cross-examination was terminated. And so that's what we were thinking, that we were going to win on appeal. The fact that my rights were already waived by not allowing me to have my own counsel, even though I was on record, and denying my right to cross-examine, even though I was on record that I did not waive any rights. We were hoping that we were going to win this on a technicality during the appeal. So fortunately, it didn't get to that point. As you could see that I'm blogging, but I wanted to address the number one, the issue of I won on the technicality. As you could see, there was no technicality. The trial still continued. It was still by the same judge, and it was still the same judge that decided and whether guilty or not, guilty or innocent, or guilty or acquitted. But as you could see, the judge made sure, and for whatever reasons, that he wanted the trial to continue, to make sure that the witnesses, that the witnesses, that everything the prosecution needed to continue the prosecution in their favor, everything from witnesses to not having my own lawyer to not even having the chance to cross-examine, was in their favor. So I've already showed in black and white, I did not win on a technicality. I repeat, I did not win on a technicality. So for all you people that are saying, number one, I won because of money, no, that's the furthest from the truth. Number two, I won in technicality. So there's the only third choice is you're going to have to accept. I repeat, the third choice, you're going to have to accept whether you like it or not. You're going to have to get past your own insecurities and jealousy. I accept the fact here in black and white that I did not win on a technicality. So for all those people that say I did, here's in black and white that I say that I didn't. Anyway, this blog has gone long enough. I'm going to go ahead and slap it together, and you guys can all discuss that. But I wanted to address the most important thing here, that all the technicality people that says that I won a technicality, I did not. So that should settle the argument, so we can move on to, and I've already kind of addressed that, like the whole money part, and which is impossible to do, and I've already mentioned it why. And then so then the last and third option is that the fact that I still won, even though that I didn't even cross-examine one of the witnesses, means that the only possibility is innocence. Anyway, this is Beb's Only, and thanks for watching. If you like it, give it a like, give it a comment. Let me know what your thoughts are. Do you still believe that money was involved? Well, as you can see, money was involved, but not to help me, but against me. And do you believe that I still won on a technicality based on just this one judge alone? Let me know what you think in the comments. And we'll continue with the further discussion of what happened legally in my case. Anyway, this is Beb's Only. Thanks for watching. Oh, I wanted to end this on a light note, on a happy note. I was in prison for 3 years, and Hero was in school, and one of his school projects was he had to create this My Shepherd, kind of like a how do you describe this? Kind of like a card, and he did this while in school, and it's titled My Shepherd, and it says right there, my dad, my hero, my best friend. And the boss was going through some paperwork, throwing some stuff out, and she found this and she gave it to me while I was gone. He made this, and I wanted to share it with you at the end of this video before I forget. he wrote this card, and it says, "My shepherd is my dad. He takes care of me. He provides everything I need. He takes me to practice soccer, and he even trains me and teaches me to stay fit and healthy. He protects me from the bad people. He's my my best friend, and I'm his unconditional love." How sweet. I love my daddy so much. And for this card, he got a 15 out of 15. So that's what Hero wrote while I was in prison when he was making this card. So it's just to show you that we didn't give up the faith, and we still moved on. And after 3 years, we were able to be reunited again. But I just wanted to share this card with you, saying that I'm the shepherd. And that's what all dad should be. Anyway, I just wanted to share that with you, what Hero was doing while I was gone. And I wanted to share you what his thoughts were about his dad. Anyway, this is Bebot's Only. Thanks for watching.